Some time ago, in 1868 as a matter of fact, the 14th Amendment to the Constitution was ratified by the states. It reads, in part, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside." This is the hotly debated Birthright clause of the Constitution. A Google search tells us that the requirement that a person be subject to the jurisdiction thereof excludes its application to children born of diplomatic representatives of a foreign state, children born of alien enemies in hostile occupation, or children of members of Indian tribes subject to tribal laws. In addition, the citizenship of children born on vessels in the United States territorial waters or on the high seas generally has been held by the lower courts to be determined by the citizenship of the parents. This is where the interpretation gets dicey. A number of courts have accepted the proposition that undocumented or illegal aliens do not qualify as alien enemies, and therefore their children, if born inside the U.S. boundaries, are actual birthright citizens, or anchor babies as they've come to be called. This first sentence comes from Section 1 of the amendment, which continues, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." This is the Equal Protection Clause used in the last half-century to promote so-called equal rights under the Constitution. Constitutional scholars take umbrage with the anchor baby interpretation, complaining that the amendment was created for the specific purpose of legitimizing the citizenship of children of former slaves. The Supreme Court's Dred Scott decision in 1857, before the 14th Amendment had been adopted, affirmed that enslaved people were not citizens, and therefore their children were also not citizens. This was a significant legal precedent that denied citizenship to a large segment of the population. The 14th Amendment, enacted in the aftermath of the Civil War and as part of the Reconstruction era, aimed to rectify this situation. It specifically addressed the issue of citizenship for those previously denied it, including enslaved people and their descendants. Now understand, the amendment did not explicitly grant citizenship to all American Indians. As a consequence, after almost 3/4 of a century, the Indian Citizenship Act of 1924 was adopted, also known as the Snyder Act. It became the first federal law to officially grant U.S. citizenship to all Native Americans, clarifying that they were indeed subject to the jurisdiction of the United States and thus eligible for citizenship. The birthright citizenship claim in a number of forms has made it to the Supreme Court. It appears that sometime in late June or early July there will be some clarification by the court what the framers of the amendment had in mind when they created it and how that interpretation should apply today. While we wait, my advice is to simply improvise, adapt, overcome, simplify.